No single individual or organisation can end domestic and family violence alone. We all need to work together to make a difference in the lives of those affected by this violence. In Queensland, the Domestic and Family Violence Prevention Strategy 2016 to 2026 has been developed to drive change across all sectors in our state. The strategy encourages partnerships between the government, community and business, and has a focus on helping frontline professionals to recognise and respond to domestic and family violence. This includes providing effective services that wrap around the victim and ensuring the legal system supports victims and holds perpetrators to account. This presentation reflects the language of the strategy. The term victim has been used to represent those who have been affected directly or indirectly by domestic and family violence. This term can also be understood as interchangeable with survivor, in acknowledgement that people can survive domestic and family violence and move on with their lives. The term perpetrator is used to represent those individuals who have carried out these acts of violence. More recently, the Third Action Plan 2019-20 to 2021-22 provides a blueprint for government and the community to keep working together to continue to deliver positive change. Such positive change relies on effective communication with each other when responding to domestic and family violence, and sharing information appropriately is one aspect of this. However, you may not know about how or when to share information in cases of domestic and family violence, so we hope this presentation will give you some new knowledge or reinforce your existing good practice. The material in this presentation is taken directly from the Queensland Domestic and Family Violence Information Sharing Guidelines. Because there are many workers around the state who encounter people experiencing or perpetrating domestic and family violence, this presentation is relevant to a range of agencies, including government and non-government organisations. During or after this presentation, you're encouraged to access, read, and consider the implications of the guidelines for you and your work area. Many of you will know that the Not Now, Not Ever report recommended changed legislative provisions for information sharing between government and non-government agencies in order to improve the safety of victims of domestic and family violence and better hold perpetrators to account. Consequently, information sharing amendments to the Domestic and Family Violence Protection Act of 2012 were passed by the Queensland Parliament in October 2016 and commenced in late May 2017. These amendments apply statewide and to all who play a role in responding to domestic and family violence. Part 5A of the Act has been interpreted for service providers in the Domestic and Family Violence Information Sharing Guidelines. This resource has been developed to support workers in the field to appropriately share information under the changed legislative provisions. To access your copy of the guidelines, type into the search engine Queensland Domestic and Family Violence Information Sharing Guidelines. Then follow the links to access the guidelines. You can download and print the document from this site. The sharing of relevant information across agencies contributes to effective, coordinated responses to domestic and family violence. Because each agency often holds different information about the circumstances and risks that are present in each particular case, information sharing is integral to effective risk management and safety planning. Without sharing information, there's a chance that the full situation won't be known, and the level of risk may not be apparent until the victim has been seriously injured or killed. Information sharing assists in creating effective screening measures, prioritising high-risk cases, and minimising any secondary victimisation, such as requiring victims to repeatedly retell their stories. The guidelines document uses some terms you may not have seen before, so let's take a few moments to define these. This will help you understand who can share information and under what circumstances this may occur. You can find these terms in the glossary on page 15 of the guidelines. The Act defines a prescribed entity as referring to the Chief Executive, Commissioner, or Principal of certain agencies with responsibilities in areas such as corrective services, justice, education, public health services, housing, child protection, and welfare. In addition, a prescribed entity may include the Chief Executive of any other department that provides services to persons who fear or who are experiencing domestic violence or who commit domestic violence. A specialist domestic and family violence service provider means a non-government entity funded by the state or Commonwealth to provide services to persons who fear or experience domestic violence or who commit domestic violence. So this includes services that work with men who use violence. Under the Act, sexual assault services are not treated as specialist domestic and family violence services unless the state or Commonwealth specifically funds them to provide domestic and family violence services. A support service means a non-government entity that provides assistance or support to persons who fear or experience or who commit domestic violence. This includes a range of services, for example, counselling, disability, private health services, such as private hospitals and general practitioners, housing, legal services, such as solicitors and barristers, and sexual assault services. An individual may be authorised by a prescribed entity, specialist or support service to share information if their duties include assessing domestic violence threats, taking action to lessen or prevent domestic violence threats. The guidelines are clear. Whenever safe, possible and practical, a person's consent should be obtained before disclosing personal information about the person to someone else. However, the principles outlined on page 5 of the guidelines underscore that the safety and protection of victims takes precedence over gaining consent to share relevant personal information. The guidelines also point to the Act's statement that the safety, protection and well-being of people who fear or experience domestic violence, including children, are paramount. Before sharing information about a victim of domestic and family violence with another agency or service, though, you should consider whether disclosing the information is likely to affect the safety of that person or another person. If you determine that the person's safety may be affected by sharing information, the information may still be shared, but you or your organisation should take steps to help alleviate any identified risks, such as more extensive safety planning or an additional referral. Remember, this safety planning should also include determining a safe way to contact the victim without the perpetrator's knowledge. There are many circumstances where it's not safe, possible, or practical to seek consent, and in almost all circumstances, consent should not be sought from perpetrators. If you possess relevant information, you need to consider several key questions to assist in your decision about whether to share relevant information without consent. The flowchart on page 7 of the guidelines provides a summary of these key steps. It's important to spend some time reading this flowchart to better understand what to do if you receive information that leads you to reasonably believe a person fears or is experiencing domestic and family violence. A prescribed entity or specialist domestic and family violence service provider may give information to any other prescribed entity or specialist domestic and family violence service provider if it reasonably believes a person fears or is experiencing domestic violence, and giving the information may help the receiving entity assess whether there is a serious threat to the person's life, health or safety because of the domestic violence. A support service may give information to a prescribed entity or specialist domestic and family violence service under the same condition. A support service is not able to share information with another support service or receive information from any entity under this provision. In other words, only prescribed entities and specialist domestic and family violence services may receive information without consent for the purpose of assessment. For the purpose of responding to serious domestic and family violence threat, a prescribed entity, Specialist Domestic and Family Violence Service, or Support Service may give information to any other prescribed entity, Domestic and Family Violence Service Provider, or Support Service if it reasonably believes a person fears or is experiencing domestic violence, and giving the information may help the receiving entity to lessen or prevent a serious threat to the person's life, health, or safety. A prescribed entity, Specialist Domestic and Family Violence or Support Services, may use information given to it to the extent necessary to lessen or prevent a serious domestic violence threat. This could include, for example, a worker from one of these services contacting the person or another person involved in the domestic violence and offering assistance or a service to that person or another person involved in the domestic violence. Page 8 of the guidelines presents Queensland's Domestic and Family Violence Information Sharing Model. Please make the time to review the two figures, which summarise sharing information for the purposes of risk assessment and managing serious threats. Under the Act, you must use your professional judgment to determine what, of the information you have access to, is relevant information that should be shared for the purposes of assessing or managing a domestic violence threat. Relevant information that is shared may be comprised of facts or opinion. Facts in this case means absolutes. For example, the date a perpetrator may be released on parole, the number of charges against a person. These are examples of facts. Opinion refers to professional opinion, inferred following the receipt of other information. For example, your own assessment that the victim is at high risk. Information, shared with or without consent, should be limited to what is needed to fulfill the purpose of sharing the information and should not be excessively detailed. What counts as relevant information is unique to each circumstance, and professional judgment is important when deciding about what information is relevant to share. Certain information may not be shared under the Act, and you should become familiar with these limitations in case they apply in your situation. The guidelines reproduce this section of the Act since it's quite specific. You'll find the Limits on Information Sharing on page 11. In particular, note the circumstances related to a person's criminal history to the extent it relates to a conviction other than a conviction for a domestic violence offence, and information that must not be disclosed under the Queensland Child Protection Act of 1999, Part 6. It's critical to remember that victims are entitled to privacy and confidentiality. Everyone values their privacy, and privacy is a significant issue in the lives of people experiencing domestic and family violence. As well, confidentiality is a core principle of intervention in domestic and family violence matters. Maintaining confidentiality is directly linked to the principle of your responsibility and accountability as a professional, working towards the survivor's safety and well-being. Ensuring privacy and confidentiality regarding the whereabouts of victims is a central principle of safety planning. However, the commitment by an agency to maintain confidentiality may impede effective communication with other professionals. So it's important to consider the broad range of legislation and policy which impact on collaborative service provision for victims of domestic and family violence. These may include professional and agency codes of practice, victim privacy, personal information privacy, as outlined in the various privacy laws and policies across states, territories and the Commonwealth, and court privacy practices. Agencies should develop their internal policies and procedures to reflect the legislative requirements in Part 5A of the Act, and model good practices in secure, timely and confidential treatment of information. Please read page 12 to learn more about this aspect of sharing information. The Act provides protection from liability for giving information. If a person, acting honestly, shares information they believe to be in compliance with the Act, they are not liable civilly, criminally, or under an administrative process for giving the information. Further, merely because a person gives the information, they cannot be held to have breached any code of professional etiquette or ethics or departed from accepted standards of professional conduct. Where a police officer receives information from a prescribed entity, Specialist Domestic and Family Service or Support Service, they may use that information to the extent necessary to perform their functions as a police officer. However, a police officer must not use the information obtained for the purposes of assessing risk or threat, for an investigation, or to proceed with an offence unless they have consulted with the entity that gave the information about the proposed use. The police officer must consult with the entity and consider whether the proposed use of the information for the investigation or proceeding would be in the best interests of a person experiencing domestic violence. The effective assessment and management of domestic and family violence risks will often involve specialist domestic violence services working closely with child protection services. It should be noted, though, that the information sharing provisions in the domestic and family violence legislation do not affect mandatory reporters' obligations under the Child Protection Act of 1999. Doctors, teachers and police officers continue to have to provide the Department of Child Safety, Youth and Women with a written report where they have a reasonable suspicion that a child is suffering significant harm and that the child may not have a parent able and willing to protect them. However, the information sharing provisions in the domestic and family violence legislation enable doctors, teachers and other service providers to share information to facilitate risk assessment and management to other people, such as a child's mother. You've taken the time to view this presentation because you're committed to creating a safer Queensland for our families. Please make the time to download and familiarise yourself with the Domestic and Family Violence Information Sharing Guidelines and share this resource with your colleagues and more broadly. Remember, the safety, protection and well-being of people who fear or experience domestic violence, including children, are paramount and should underpin all of our work, including communicating within and across our agencies.